Hello and good morning, everyone. My name is Jillian Bender-Cormier. I'm brand manager with Bender Insurance Solutions. We want to welcome you to another educational Bender U webinar discussing workers' compensation in the first 90 days. Some housekeeping notes. If you have any questions during the webinar, please feel free to type them into the chat box or in the Q&A section. We'd like this to be an interactive experience, so our presenter will be available to answer your questions in real time throughout the webinar. During additional Q&A time at the end of the presentation, I will be sharing other questions you might have with our speaker. We want to be conscious of time, so if we don't get to answer all of your questions, we will gladly reach out to you individually after the webinar. You are all in listen-only mode and will remain muted throughout the webinar. This session is being recorded. At the conclusion, the recording link as well as a copy of the slide deck will be forwarded to you. We have an incredible expert sharing with us this morning, but I'll let our own construction and agriculture risk advisor, Lisa Wilson, have the honor of introducing him. Welcome, Lisa.
Thank you so much, Jillian, and welcome everyone on the call with us this morning. I am thrilled to be able to share Saul Pazar with you. He joined our firm in 2021 with over 7 prior years experience in California workers' compensation claims. He now has over 9 years experience working between a claims examiner for carriers, third-party administrators, and as a claims consultant for national and retail insurance brokerage firms. He is a strong advocate and support for our clients when there are claims or potential claims, and has helped me with several claims to move them forward in ways that hold the claims adjuster accountable and get the treatment needed for employees, and also inform employers of their rights and responsibilities. It's my pleasure to introduce to you Saul Pazar.
Thank you, Lisa. Hello, everyone. Good morning. Happy to be here. We're going to be talking about workers' comp claims and the first 90 days. This is going to be a general overview of the claims process in the first 90 days and what you can do on your end to make it a little bit better for you in terms of the managing and handling of the claim to make sure that the first 90 days go the right way. The agenda for today, we're going to talk about workers' compensation benefits overview. We're going to give you steps of when a claim is first reported and what to do, the difference between accept, deny, delay. We're going to talk about medical treatment, separate disability, and the importance of having a return to work program. So let's just start at the very beginning. Why do we have workers' comp? Well, workers' comp started because there's something called the grand bargain or the great bargain. And what that is pretty much an agreement between employees and employers that said, hey, instead of having employees sue the employer whenever an injury happened and having the employee have to prove their case and pay for litigation costs to say that the employer was responsible for that injury, and then if it's found that the employer was responsible, then they get this huge settlement for it. Instead of having that, we're just going to create our own system where the employee is going to get medical treatment and benefits if they get hurt, and they won't sue the employer for any other extra stuff that they could get in other courts. And that's how workers' compensation came about. Workers' comp is a no-fault system, meaning if an injury happened, it doesn't matter who's at fault for the injury, whether it's the employee's fault, it doesn't really matter because they're still going to be covered. One important thing to remember, at least in California, is that California workers' comp is governed by the Labor Code and the California Code of Regulations. California Labor Code 4202, which is my favorite labor code because it tells you pretty much how the system's set up in California. That labor code says that workers' comp law shall be liberally construed by the courts with the purpose of extending their benefits for the protection of persons injured in the course of their employment. So what that says is, hey, if it's an incident and there's anything gray area that we're not sure about, or any questionable things that are not concrete facts, it's going to be found on the benefit of the employee so they can get benefits, right? So it tells you right away, hey, the employee is going to get a lot of leeway in the system to make sure that they get the benefits. And on the other hand, the employer needs to prove with 100% certainty that something didn't happen in order for a claim to be denied and in order for that employee to not get benefits. So some might say it's not a fair system, but it's a system we have, and it's all based on this labor code that pretty much sets it out. In California, workers' comp litigation goes through the WCAB, which is a Workers' Compensation Appeals Board. The WCAB has their own judges who rule on workers' compensation cases. So all that goes through the WCAB. In workers' compensation in California, we have 5 main benefits. The first one is medical treatment or medical benefit. Temporary disability, that's an indemnity benefit, and that's when somebody's off work because of the injury, they get paid for the time off. Permanent disability, also an indemnity benefit. That benefit is really at the end of the claim when they're done treating. If at that point your doctor determines any impairment due to the injury, then it will equal to a certain amount of money to be paid bi-weekly until the amount is paid. The fourth one we have is supplemental job displacement voucher. This one you might not know just because it happens at the end of the claim and it's also handled by the examiner, but this one is only given if the employee has permanent work restrictions at the end and you're not able to bring them back to work. So if that's the case, they may be entitled to a voucher for retraining. That voucher is up to $6,000 to be allocated in certain areas for education. And the last benefit we have is the death benefit. Hopefully you haven't come across this one very often, but somebody that's at work, obviously they want to get medical and temporary disability or permanent disability, but their dependents would get death benefits in a set amount set by the state that will be paid out. So you have a claim, now what? The first thing, the most important thing is the DWC-1 form. Is an employee tells you, hey, I'm injured, or you saw the injury happen, or they broke a bone and went to the hospital. Whatever the case may be, if somebody tells you or you saw an injury, the first thing you should do is give them a DWC-1 form. The DWC-1 form, also known as the employee claim form, looks like this. It's 4 pages long. So the first page just tells them about the benefits within workers' comp. It also does it in Spanish. Second as well, the third page. The page we care about is the 4th page. This is the page the employee needs to fill out in order to submit a claim. They fill out the first section right here and give it to you. Then you fill out the second section, and then you turn it into the carrier to open a claim. Now, technically speaking, we do not have a workers' compensation claim if an employee did not give you a signed DWC-1 form. This is the starter for the claim. So this is really important for you to give to the employee because that's how they make the claim a workers' comp. Also, within the labor code, California Labor Code, it is your duty as the employer to give this form to the employee when there's an injury. And things can happen if you don't give them, if you have knowledge of an injury and you didn't give the employee the form. So my recommendation is give them this form, document it in your file, whether it is given to them via email, so you have a copy of that. If your employee doesn't have email, send it via mail and send it certified, so you have a proof that it was sent out and it went out. Or if you do it in person, have him sign a form saying, hey, I received my DWC-1 form. Simple as that, and have him sign it and date it. It's just really important because if you have knowledge and they'll give this form, it can create issues down the line. So if an employee tells you I'm injured or I might have an injury and you give them the form, but they don't give it back, you don't have to file a claim until you get that form back. And at that point, you file the claim. There's exceptions though. If there's an injury that is more clear-cut, where somebody tripped, fell, went to the doctor, I'm not gonna wait for that form to come in because I know an injury happened. I know he fell. They might have a broken bone. So I'm not gonna wait for that form to come back to me signed. I'm just gonna report the claim right away. When we have a situation where the employee is coming to you saying, my back has been sore for a couple of days, I'm not sure how it happened, where it happened, I'm not sure. I think it might be because of work, because I'm doing this continuous work. In those situations, you give them the form and say, hey, this is the claim form for workers' comp. If you want to file a claim, just fill out the top section, give it back to me, and we can file a claim for you. But in those situations, you can wait for the form to come back to you in order to be able to file the claim. The first thing also that you do after you give them the form is you offer medical treatment. This is also one of the duties of the employer when an injury is reported. So typically when you are insured by the carrier, the workers' compensation carrier will have an MPN, medical provider network, and that you would select a main office that you go to within that network that you send your employees to. So whenever somebody tells you, hey, I'm injured, give them the DWC-1 and offer them medical treatment. Sometimes the employer would tell you, hey, I really don't want to go to the doctor, which is fine. They don't have to. It's their right to say, no, I don't want treatment. If that's the case, I recommend you make them sign a medical declination form. That form can be really anything, but this is a very simple one that a carrier has that pretty much says, hey, I, so-and-so, know I'm entitled to workers' comp, I have an injury on this date, this body part while doing this job, and I don't want any medical treatment. Also, this one also included the part that says I was provided the DWC-1 form. So by having them sign this, is just reinforcing the fact that you offering the medical treatment, that you give them the form, and it's giving you proof down the road to say, hey, I did give you this, I did offer medical treatment, you declined it. So it's just very helpful to have, because sometimes you think the claim is not gonna go one way, or they're not gonna file a claim, but 30 days later, they get an attorney and it's a whole different story. So it's a good way to keep records of this and keep it for yourself on the road. Also, really important to do is to do an actual employer investigation. That includes having accident reports, statements, video, photos, social media, and to do it as soon as possible from when the injury happened or the injury was reported. It would be really good for you to have a formalized process for all of this and to do it through all the claims that you have. So that way it's the same every time it happens. And I'm going to show you a few examples of accident reports that are out there that you can use as a template to create your own. This one right here is from the city of LA, and it's public information. Go anywhere to get it, but it's out there. And this is what the city of LA does within their workers' compensation claims process internally when something's reported. So they have this packet, they have a frequently asked questions, but the part that I care about is this right here. They have a template, a form to give to employees to fill out when they have an injury. And it goes over providing just basic information like date of birth, address, all that stuff. But also it goes over describing how the accident happened, were there any witnesses, what are the complaints. It's really good to have this right away because a lot of times the story changes from when it first reported until later. And if we don't have it documented, then it's really hard to prove that the employee told us one thing to begin with. So by having something formalized, by having something written and signed by the employee, it's there. How is the employee going to say that that was not the case, right? So this is really good to have and have the employee fill out at the beginning. Also, here's a witness statement form. This is also really good to have. If we know that when the injury happened, there were witnesses, it's really important to have those witnesses fill out a form right away, saying, hey, I was a witness, I didn't see anything happen, I don't know what he's talking about. Or the opposite, hey, yes, he fell tripping over a piece of wood. Whatever the case may be, it's just really important to have this documented up front and not wait until we get a call from the examiner asking, hey, are there any witnesses? Have you talked to them?
Hey, Saul.
Yes.
We do have some questions that have come in. And the first one is, what about when the employee has multiple jobs and it's accumulated pain? Do I still offer the DWC one?
Yes. So you do have to offer it because it's not up to the employer or even the examiner to determine if our job caused the injury or what part of our job attributed to the injury. That will be the doctor's job. So what happens is an employee comes to you saying, hey, I think I'm injured because of work. But we know that they have 2 other jobs that they work on the weekends or at nights. So your job as the employer is to say, okay, here's the DWC1, here's the claim form, fill it out. Also, here's medical treatment if you need it, go here. As soon as that happens, report the claim right away. We don't want to wait for the DWC1 to come back. We just want to report it away. And then we tell the examiner, hey, this happened, this employee's telling me this. But I know for a fact he's working somewhere else. And these are the places he's working at. I'm not sure what hours, but I know he's working somewhere else. Please investigate it right away. What's going to happen? The claims examiner is going to delay that claim. They're going to do an investigation. And they're going to really go into it and try to get information from the employer regarding the other employment they have. Also, the examiner will inquire with the doctor and say, hey, doctor, I know you saw this person, but were you aware that he has this other jobs and this is what he does? Can you please let us know whether that could have contributed to the injury? So it's not up to, in workers' comp, everything's driven by medical reporting. So it will be up to whatever the doctor says regarding those other jobs and how they break it down in terms of causation.
Thank you so much. And I have one more question. Well, actually 1.5. Can you require the employee to get medical attention prior to returning to work if they decline treatment?
So that kind of jumps a little bit into HR, which is not my specialty, but in workers' comp, we cannot force an employee to seek medical treatment. It's up to them to do it. So I think several issues might arise though, because what if, let's say, they have a broken arm and they don't want to go to the doctor? Well, you need to come. I guess if they have visible limitations that you're concerned about, then perhaps that's something you could explore in the HR issue to determine, hey, within HR rules, can I do something to make sure that this individual is capable of working? But within workers' comp, no. I cannot make somebody go to the doctor if they don't want to. The same way that I cannot make somebody get a surgery if that's not what they want to get done, even though the doctor says it's necessary.
Thanks, Saul. And then just one person was wondering if they would be able to have access to the declination form that you shared.
Yes, so Jillian will be sending out an email later today or in a couple of days with the link to all the documents I'm showing you, just because all those documents are public domain, public information. So you'll have access to those.
Perfect. Thanks, Saul. That's it for now.
Thank you. The other form we have within the investigation package that CDLA has is a supervisor investigation form. This is also really important because a lot of times an employee will report a claim to their supervisor, but maybe not HR or the person who's in charge of workers' comp claims within your company. So the supervisor knew about a potential injury, but never told anybody. So this is just a way to make sure that the supervisor is aware of what's going on, maybe also has information about the injury. But not only that, maybe you can see a gap in here in training where the supervisor says in the note, yes, they told me on this date, but now we're 30 days down the road, and we just heard about it, right? So it can help you determine whether there's any gaps in training when it comes to workers' comp claims within your company. This one is also very nice. This one is not necessarily a claim, just a near miss. So an injury almost happened, but it didn't happen. It's a good way to document it and report it. And maybe we get several near misses that are the same. Well, that will tell you that there's a little bit of gap in training or safety, or maybe the way that is being done should be changed. I'm going to show you a different one because the city of Lake, it's great, it's in depth, it has a lot of information. See if it's working. There we go. This one is from UCR, and this one is a lot more simple. It's just an employee statement. You can see it's a one-pager, and the supervisor statement. Again, pretty simple one statement. So it doesn't have to be this huge packet. It's whatever fits your company and whatever fits for you. So this is just same kind of idea, just in a much smaller scale. So to actually report the claim to the carrier, you can do that via email, fax, or phone. It's whatever works best for you. Personally, I would recommend doing it via email because that way you have proof that you reported it. You have an email, copy of the email you send out. You can add attachments to it, whether it's all in the accident reporting you did already. You can attach that, any statements, any video, photos, anything like that. You can attach that to the report. Also, one thing you do need to do when you report a claim is you need to send out the 5020, the employer's first report. I'm sure you are familiar with this, but this is the form that needs to go out when you send out the first report of the claim to the carrier. It's a lengthy form. Fill it out to the best of your knowledge, because a lot of times you may not have all the information at the beginning, but this is a form that needs to go out with the report of injury to the carrier. It's the 5020, form 5020, or the employer's first report. I'm sure you've seen this already. If you report the claim via phone, the carrier will fill out this form for you based on the information you give them over the phone. Also, I mean, that's something to remember. If you don't want to fill out the form, you can call in the claim and then just send all the supporting documentation via email later. Some of the tools we have when we have a claim are social media check, background check, and sub rosa, or surveillance. Social media check can be done very easily. Some carriers are doing social media check on the front end without even us requesting it. Some of them are not. A background check, that one is a little bit more cumbersome and does require us to request it. Surveillance obviously costs a substantial amount of money, but if warranted, can be done. So this is tools we have that we can request the examiner to do. All we have to do is to make sure that we requested with a specific purpose. Otherwise, it can be denied by the carrier, but just something to remember when we're handling our claims and doing the investigation process.
Hey, Saul, I have another question for you.
Sure.
Currently, we have employees complete the DWC-1 upon injury, even if a claim is not filed. Is this a concern?
It might. Yes, potentially, just because if they fill out the DWC-1, then a claim is filed. If an employee fills out the DWC-1, you need to submit that to the carrier because the DWC-1 is the employee claim form, and it's the form they submit to report a claim. So it needs to be submitted to the carrier. So if the employee does not want to file a claim, then they don't have to fill it out. But your duty as the employer is only to give it. Give it to the employee and have them fill it out if they want to file a claim.
Okay, thanks, Saul.
Okay, so once a claim is reported to the carrier has to accept, delay, or deny a claim. Per workers' compensation law, the carrier has 14 days from date of knowledge to accept, delay, or deny. Let me just start by saying the 14 days is very lax. Technically, they do have 14 days, but it can go beyond those 14 days. But it's really important to just report the claim as soon as possible. Once a claim is reported, the claims examiner would look at the claim, and in order for a claim to be found work-related or compensable, it needs to arise out of employment and in the course of employment. AOE, COE. You probably heard this term before. This is just what the law says determines whether an injury, an event, an incident is work-related or not, and whether it's covered by workers' comp. Just what it means is at work because of work. It needs to fit those things. And it goes beyond just was he getting paid or not. Really, anytime an employee is doing anything for the benefit of the employer, even if they're not getting paid for it, there is really not adding anything extra to them, but it's for the benefit of the employer. And something happens, that incident might be found work-related. For example, you have an employee who was going home from the office, and on the way home, they picked up an order for you that was supposed to be picked up just as a favor. They're not getting paid for it. It's on their way home. They're just gonna go pick it up. Well, on the way from the office to pick up the order, they get in a car accident. Well, guess what? Because they were doing something for you, even if they were not on the clock, even if not really within their job description, but because it was for your benefit, for the benefit of the employer, that might be found compensable and work-related. So it's just something to remember. And this is what the kind of the thinking the examiner will do and go through when determining whether a claim is compensable or not. So if a claim is accepted, we'll provide benefits. We'll provide medical and temporary disability benefits at the beginning, and then permanent disability benefits at the end if they're due. If a claim is delayed, then the claims examiner has 90 days to complete the investigation. Sometimes the examiner will send out an actual investigator to you to interview witnesses, to interview you, to talk to the employee, maybe get some pictures if something is questionable or we're not making sense. So that will happen for those cases that are a little bit more complex and we're just not sure, what happened. And it's good for the examiner to do this because we get those statements recorded by the investigator, which is really good. Also, within this delay period, within this 90 days, no temporary disability benefits are due. So if a claim is placed on delay, the employee is treating and they're off work, workers' comp is not going to pay any benefits for temporary disability until a decision is made. And if a claim is accepted down the road, they will go back and retro pay for those days missed from work. But until then, no payments will be issued. Also, there's a limit of the medical treatment an employee can get within those 90 days, and that limit is $10,000. So the employee cannot get more than $10,000 of treatment within the first 90 days. Typically, it's not an issue because at the beginning of the claim, the employee is treating conservatively through physical therapy, medication, nothing really too crazy. But every now and then we get a surgery that is trying to get through on day 60 and the negotiation is not done. Well, the examiner is not going to approve that surgery because that would definitely go over the cap of $10,000. So that won't be addressed until after whether the claim is accepted or not. Something really important to remember, those 90 days that the claims examiner has to investigate the claim, they start from the employer's date of knowledge, not from when the claim was reported. So that's why it's really important for you to give the form to the employee as soon as you have knowledge. Let me give you an example. Let's say that you have an employee that had an injury on 1/1, and they told the supervisor that they had an injury, but they didn't want any treatment. The supervisor didn't do anything because they don't want to file a claim. They don't want treatment, right? Well, now on 3/1, you get a notice of representation for that injury and that employee, saying that an injury happened and that happened on 1/1. You do your investigation, and during that time, you find out, hey, something did happen. They declined treatment. The supervisor just didn't do anything about it because they didn't want to file a claim, and the employee was not given the DWC-1. Well, now our 90 days start from 1/1. They don't start from 3/1 when we got the letter from the attorney. They start from 1/1 when our supervisor was notified of the injury and we have knowledge of that injury. So that's why it's really important to do the investigation. Now, let's say that instead of that, what happened was on 1/1, somebody has an injury, your supervisor was informed, your supervisor knew the process and knew what to do, so your supervisor gave him the form and said, hey, this is the claim form, fill it out, give it back to me if you want to file a claim. It never gets turned back to us. Now in 3/1, we get a notice of rep from the attorney. Well, in that case, our 90 days will start from 3/1 because on 1/1, we were notified of the injury, your supervisor gave him the form, which is the duty of the employer, it was just not given back to us. So you fulfill your duty of having knowledge, give him the form, so therefore our 90 days don't start on 1/1, they start on 3/1. So now we have back those 60 days to do the investigation. So that's why the claim form is really, really important, because it sets the timing for everything that happens afterwards. Lastly, if a claim is denied, denials are based on legal, medical, or factual evidence. There's no benefits paid. Employees usually treat within on a lien basis, so they go to a doctor, we just treat them without charging the employee, and we'll send a lien to the carrier for the treatment. And typically, when we have a denied case, the employee will start the QME process, the qualified medical evaluation process, that we'll go into a little bit farther on the next slide. Okay, medical treatment. Let's just start with this form. You're never gonna see it because it's medical information, but this is what it looked like. This one is a 5021, doctor's first report of injury. So anytime an employee is injured and goes to the doctor for the first time, the doctor will fill out a 5021 and submit it to the carrier. So it looks like this. Information, how the accident happened, complaints, objective, subjective, any diagnostics done, given a diagnosis, treatment rendered, and causation. Is this work related or not? And this is done every time. And the claims examiner will get this along with the billing for that medical office visit. This is what it looks like. You're not going to see it ever, just so you're aware of what it is and and how it looks like. One thing to know though is that the doctor's obligated by law to fill out this form when somebody's seen for the first time for a workers' comp injury. And they're obligated by law to send it to the workers' comp carrier. So sometimes what might happen is you have an employee who was injured but just never told you, and they just went to the doctor. And they went to the doctor, they told the doctor, hey, yes, I got injured, it happened at work. Well, now the doctor needs to fill out this form. And somehow your employee knew your workers' comp information because you do have those postings on the break room saying, hey, this is our workers' comp carrier, and this is their mailing address and all that information. So he has that information, and they gave it to the doctor. Well, now the doctor's going to send this form to the carrier, and the carrier's going to open a claim, right? So that's how sometimes we can get claims that we knew nothing about because your employee went to the doctor and told them what happened at work, and the doctor sent this form. So just something to remember and know how a claim can be reported without you knowing about it first.
Hey, Saul.
Yes.
We have a question that's come in. When is the practical time to give an employee the form of declining coverage if they don't turn in the DWC-1, and that's using your 1-1 to 3-1 example?
Are they talking about the medical declination form?
Yes.
Okay, so that form, I would give it as soon as the employee tells me, I don't want to fill it out, I don't want to file a claim. At that time, I was like, well, okay, that's fine. You don't need to, but can you just, in that case, just fill this out? It just goes over saying, hey, that I talked to you about offering you medical treatment, that I talked to you about this form, the DWC-1, and that you don't want to turn it in, just for your record and my record. And so typically I would do it, I wouldn't do it right away with the DWC-1. I would give them the form first, and then if they don't return it, then I would ask for the declination to be signed. If they told you right away they don't want to do it, then I would do it right away, give them the other form. If not, I would probably wait a couple of days and be like, hey, I gave you that DWC-1. Are you going to file a claim? Are you not? If you're not, then can you just file, sign for me this medical declination? It's just saying that you don't want medical treatment. But also, if you want it down the road, then I guess you can give me the form then, but it's just for now, right? Because what can happen is they can sign the medical declination form, but then 2 weeks later say, hey, never mind, I want treatment. Here's the form, right? But and that's fine, but it gives them that option.
Wonderful, thank you.
So medical treatment is, all the carriers have a medical provider network, an MPN, which means the employee has to treat within that network. It's the way to control medical costs, because that way the carrier has somewhat control over the MPN and who's in it, and they're able to select doctors who know the system a little bit better and can treat the employee within the parameters and rules of workers' comp. It's really important for you to find your own occupational medicine clinic of choice when treating for treatment, and to have a relationship with that clinic. It goes a long way. So, sometimes when there's a referral to a specialist, and it's really hard to find that specialist because of the area where the employee is, or just the type of specialty that they're asking for. Having a relationship with the clinic can go a long way. So them knowing who you are. Also, when you have a relationship, it's a lot easier for you to call the clinic and actually ask, hey, so-and-so went today, but I'm noticing that his complaints are not matching how he's moving around. Can you maybe ask the doctor about that? That can go a long way. So just make sure you have a clinic that you use and establish some sort of relationship with them. For medical treatment, everything has to go through utilization review, UR. So what happens is a doctor says, hey, I saw this person, they need physical therapy. Well, the employee is not just gonna get physical therapy. The doctor needs to fill out an RFA, request for authorization form. That goes to the carrier. Once received, the carrier has 5 days to do the review and determine whether that treatment is approved or not. And then they'll send a letter to the doctor saying, hey, doctor, this is approved. And then at that point, the doctor's office will schedule the physical therapy. So as you can tell, the medical treatment can take a while just because of all the paperwork that needs to happen in order for the employee to get treatment. So typically what we see is the employee gets treatment, goes for the first visit, they might be placed on temporary disability for a short time, and then they get a release to modified duty for some other time, then we get a release to full duty, and finally we get an MMI, maximum medical improvement. So that's typically the sequence we see when we have an injured worker. Sometimes we just see treatment, modified duty right away, release to duty, MMI, which is great because that way we're not paying any benefits, but that's the sequence that we see. At the end of treatment, the doctor would do an MMI report. In that report, the doctor would list permanent work restrictions, permanent disability, and the need for future medical care, if any. So something that we can go into a whole different webinar about, but it's just something to keep in mind. Tools that we have within medical treatment are field case nurses and telephonic nurses. As the name says, the field case nurse goes to the doctor visit with the employee, and they're there to ask questions, but also help the employee. A lot of times, the employee doesn't understand what the doctor's saying, or the doctor just doesn't understand the employee. So having a medical person in there that speaks both languages in a sense of the medical language for the doctor and just the everyday language for the employee can go a long way. Also, a lot of times, the employee would tell us one thing about the medical visit, and then the report says another. So you don't know which one to believe because the examiner is telling you that report is saying X, Y, and Z, but the employee is telling you a completely different story. By having a nurse there, it can clarify a lot of things. And a lot of times, if we have an issue in medical treatment, having the nurse just for one visit go in fixes the rest of the treatment down the road. So it's a tool that can be used. We can request it on our end. We don't have to wait for the examiner to just ask for that on their own. We can request for a field case nurse to attend an appointment. Typically, it's better for just do it for 1 or 2 visits, not on for the whole length of the case. But if a case is more complex, if the injury is more complex, we might ask the nurse to be there for maybe a month or 2, right? So just something to keep in mind. The other type of nurse we have is a telephonic case nurse. That nurse is telephonic. So they'll contact the doctor's office after the visit, ask for any documentation, ask for any requests for treatment, assist with any transfer of care to any specialties if they're having difficulties. So those are kind of the options we have when it comes to nurses. Lastly, there's something called the Qualified Medical Evaluation, a QME. This is when there's any dispute in medical treatment and work status, impairment. Either side, either the employee or the clinic examiner, can request a panel from the state. That panel will give you 3 doctors, and the employee will have an evaluation with one of those doctors. All the medical records are sent to that doctor. The doctor will do a full evaluation, and then the doctor will provide a report regarding the injury, the treatment, whatever the issue is, and give an opinion. Typically, a qualified medical evaluation opinion carries more weight than the opinion of the primary treating physician. And it can resolve sometimes issues whether somebody is not MMI yet or somebody is not full duty yet. So it's a tool that we can use. I like to wait a little bit and not jump to this tool right away because, like in everything, we have QMEs that are very liberal and we have QMEs that are a little more conservative. And because it's the panel with 3 doctors, I don't know which 3 doctors I'm gonna get. So it is a little bit of a gamble sometimes. So it's a tool to be used at the right time, but it's something that we do have.
So I have a question for you. As a general contractor, are we safe to assume that if an employee of a subcontractor is injured, that these reports will be filed by the subcontractor with their insurance? Or do we need to verify that the proper documentation is completed?
That is a great question. And I guess it depends whether there's an OSIP or not within a project. An OSIP is an owner controlled insurance program. And I'm assuming based on the question that there is no such thing, right? So if within your contract, it says that the subcontractor would treat and manage, will manage all their claims for their employees, then it's really up to that subcontractor to do it. And yes, I guess best practices would be to make sure that that subcontractor has some sort of program for workers' comp claims internally, that the way they handle it. And I don't know if you're able to request that on the front end when you're hiring those subcontractors. But at the end of the day, it would be up to the subcontractor to make sure that the claims are filed correctly and that are handled. Also, technically, there will be their employees, not yours. So we'll fall under that subcontractor's policy, as long as there's no OSIP kind of arrangement for that particular scenario.
Thank you.
Temporary disability. So temporary disability is pretty much wage replacement. So if somebody is off work because of an injury and either TTD, temporary total disabled, or a modified duties, and those modified duties cannot be accommodated, the carrier will pay temporary disability. Temporary disability is 2/3 of the average weekly wage, 8WW. So how is that calculated? The carrier will ask you for wage history from the date of injury going back a year, 52 weeks. Once that information is received, the examiner will add up all the earnings they had, including bonuses and any other earnings that they had, pre-taxes and pre-deductions of benefits. And they will add it up and divide it by the number of weeks. That will give the examiner that AWW. Based on that AWW, the employee will get paid 2/3 of that. For example, if the employee gets information, the examiner gets the information, and we have an AWW of $900, then the temporary disability rate is going to be $600 weekly, because that's 2/3 of the AWW. In workers' comp, we have a 3-day waiting period. So an employee would not get paid for the first 3 days of time lost from work when they're placed off work by the doctor, unless they're off work for more than 14 days. If they're off work for more than 14 days, then the waiting period is waived. So, but if they're only off work for 10 days, then waiting period is not waived and they will not get paid for the first 3 days. By law, there's a maximum of weeks that the employee can get for temporary disability is 104 weeks, so which is 2 years. So an employee cannot go past 2 years of receiving temporary disability. Once that happens, even if they're still off work, they're not going to get any more temporary disability payments. By law, also, the employee needs to be seen by a doctor and have an updated work status at least every 45 days. If the employee goes beyond 45 days without getting a new work status, the claims examiner can send a letter out saying, hey, we're going to stop payments, so you're going to see the doctor. And if they don't see the doctor, even after that letter, then the temporary disability payments will just stop because we don't have an updated work status. Also, there's something called temporary partial disability, which pretty much says, hey, somebody's working modified duty, but instead of working their full hours, they're working half time, 4 hours. Well, workers' comp will come in and pay for the difference between what their AWW, what they're earning now, and they'll pay 2/3 of that difference between that. Again, this is not something you would do on your end. It's just something to keep in mind of what the claims examiner will do and what kind of information they might need if this is the scenario, right? So you don't need to know this by heart. It's just a good way to, it's just good information to have access to. But at the end of the day, the examiner will be the one in charge of working through all these calculations and making sure it's correct. This is just a permissibility table. So in California, when somebody is MMI, a doctor will determine an impermissibility. You don't need to know this. I'm showing you this because let's say that after treatment, somebody is found to have 10% permissibility. Well, 10% permissibility is, and we'll go to this table right here, which is 2014 and beyond on the far end. So 10% disability is equal to payments for 30.25 weeks at $290 per week for a total of $8,772.50. The higher the permissibility percentage, the higher the payment. 30% permissibility is equal to payments for 126 weeks at $290 per week until a total of $37,990 is paid. So this is just some information for you so you can see what the permissibility payments and amounts look like. So what's the best way you can reduce your claims, the payments on your claims, is by having a return to work program. A lot of the money spent on a claim comes from indemnity benefits more than medical. It comes from temporary disability and it comes from permanent disability. And between those two, the one that you have the most control over is temporary disability. You can do this by, there's a few methods. One of them is salary continuation. So if somebody off work, instead of having the carrier pay for a time off from work, you can just continue to pay salary. That would mean that the carrier will not pay for benefits, you will, so therefore it will not show on the claim. If you're gonna do this, it's really important to have a set standard of when you do salary continuation, for how long, and to have it in your handbook, just because you don't wanna make sure that you don't do it forever. And maybe it would be good to do it for the first 2 months, and after that, not to do it and have the carrier pick it up if somebody's gonna be off work for longer than that. But it's a good way to control the expense of indemnity in a claim. Another thing you can do is offer modified duty. And a lot of times, I know you're concerned about bringing somebody back to work when they're not 100% or they're not able to do 100% of their job. But finding ways where you can create jobs that would fit in with a certain modified duty restrictions can go a long way, because that way you bring the employee back to work, you keep keeping them engaged with work. They're not just at home sitting, looking TV or talking to friends. Also, you're reducing the amount paid on the claim because he's working, you're paying him for work. The carrier's not gonna pay for that. So it just goes a long way to bring somebody back to work as soon as possible. It's really good to have something formalized, meaning you already know that somebody gets an injury, what kind of job you can offer them right away, because you already did your work and you know what you can accommodate. If by any chance you cannot accommodate some restrictions because they're too severe, there's something called alternative work program. What this does is this is a program where they find a nonprofit and the employee will work for the nonprofit, and then you'll pay salary while they're working for the nonprofit. And you can pay them a minimum wage, you can pay them the full salary. That's really up to you, but they're engaged, they're working somewhere else. And you're reducing the cost and the amount being paid under the claim for indemnity. Most carriers offer this program, and they will pay for the fee, placement fee as well. So just something to keep in mind, and something to know that you have access to when you have a claim with somebody as a modified duty for a long time. Again, whatever you do internally to try to reduce the cost of indemnity and temporary disability, make sure you have a formalized program. Make sure that it's somewhere in your handbook or your process and procedures for workers' comp claims, whatever it is, just have it somewhere, because we want to make sure that it's something that is applied to all your employees, regardless of who they are. Because the last thing we want to get is somebody claiming that somebody's being favored over somebody else because this person got solid continuation, but this person didn't. And why was that the case, right? So make sure that it's the standard procedures applied across the board, and you have it somewhere within your procedures. At the end of the day, reducing indemnity reserves paid reduces the amount paid on the claim, which reduces the impact on the XMOD, which at the end of the day, that's one of the things we care about the most, right? Some other important takeaways that we didn't discuss in this particular presentation because it would take a lot longer, but just know that litigated claims stay open longer. That's just how it goes. Anytime you get a case that becomes litigated, expect it to be open for an extra 6 months to 12 months. The best way to avoid litigation is to maintain contact with your employee, claims examiner, or medical office. Most importantly, maintain contact with your employee. Talk to them after each visit. Hey, you went to the doctor. Do you have a work status? Can you send it to me? How did it go? The doctor say you're improving, or they're not? They're gonna ask for any treatment? Just keep that communication open, because a lot of times what happens is the employee just doesn't hear from anybody, doesn't hear from the claims examiner, doesn't hear from the employer. They don't really know what to do. They're kind of a little bit lost. So just by having somebody there, and goes a long way, but also the employee knows that you're checking on them. If you know they have an office visit, they know they're gonna get a call from you asking for the work status. So again, make sure they get it. And also, it's a good way to find out about issues that perhaps you don't know what's going on, right? If the employee tells you, hey, I've been waiting to get an MRI approved for 3 weeks now. Hey, what's going on? Let me talk to the claims examiner, email them asking, hey, was an MRI request received? Has it been approved? Can we get that looked at? Whatever the issue may be. Lastly, use your resources. Use your broker. Use me if you have somebody within the broker's office who does that. But use your resources to make sure that any questions or issues that arise are addressed. You shouldn't be expected to know the workers' comp claim system inside and out. You have a lot of other things to worry about. So rely on the experts that you have to help you through that process. Now, Jillian, if we have any further questions, we can address them.
Yes, we do. One of the questions is, do you have a sample of a return to work program that you're able to share, Saul?
I do not have a sample of that at the moment. I am working on putting one together of a return to work program. But what I can do is I can do a quick search online and see if I see any templates of good ones and send it your way through Jillian.
Okay, perfect. Another question that I have is, if an employer chooses to do salary continuation, does this affect their mod rate?
So the XMOD, I feel like we can do a whole presentation about the XMOD. So the XMOD, as you probably know, is the way that your company is compared to other companies in the same industry, and in terms of workers' comp claims and safety, really. So in the XMOD, there's something called a primary threshold, and that it's a certain amount of dollars. So let's say that you have a primary threshold of $10,000. Well, any claim that has indemnity and medical paid, because expenses is not included, it's only indemnity and medical. Any claim that has medical and indemnity paid between $250 and $10,000 is going to have an impact on your XMOD for a certain amount based on where they are. So if a claim is only $300, that's going to have a very little impact. But if a claim is $9,000, it's going to have a lot bigger impact. Once the claim goes over the primary threshold, so let's say now we have a claim of $75,000. Well, it doesn't really matter between 10,000 and 75 how big it is, because it gave you the biggest hit it can give you on the XMOD. So one good thing to know is what is your primary threshold, and that is within the worksheet, the WCRB worksheet. It tells you that amount, because if your threshold is very low, well, if you do site continuation, it doesn't matter. It's not going to matter because the medical treatment is probably going to get to it anyway, right? So knowing in terms of the XMOD, knowing that information will help you make the decision whether site continuation is a good idea or not for your company. Also, yes, anytime you're paying instead of the carrier, then it's not going to show on the claim. So therefore, that particular claim is going to show much lower for the total paid on indemnity or medical. Well, indemnity in this case, since we're talking about site continuation. So yes, but it's based on the primary threshold that you have for in the XMOD, and it's just an analysis that needs to be done on your end. Also, don't get carried away with site continuation, because I mean, at the end of the day, you are paying insurance, you are paying a premium, and part of that insurance is paying for benefits, right? So don't try to cover all the indemnity, temporary disability payments, because then what are you paying a premium for, right? So make sure that you do it smartly, and that's why I say maybe do it for a short amount of time to see if that way we can eliminate that particular payments and the employee comes back to work. Then it's nothing paid on that end, but this is a evaluation analysis that needs to be done on your end to determine that.
Thank you, Saul. And we do have additional questions, but we do, of course, want to be conscious of everybody's time and schedules, because it is a couple minutes past 10. So for those of you that didn't get your questions answered, we will definitely reach out to you individually after the webinar. Thank you so much, Saul, for sharing with us today. I wanted to get on everyone's radar our next Bender U. It's going to be on April 20th. We're being a little funny here. Let's be blunt. How to handle impaired employees. This is going to be a wonderful hybrid session, meaning that we are going to be offering in-person and virtual attendance. There will be snacks, there will be treats. It will not be recorded. So if you want to join in, you need to attend. So go ahead, scan that QR code. I will also be sending out all of the details on that following today's webinar. In addition to that, I'll be including the slide deck, as well as a link to view the recording from today's session. Again, should you have any questions that arise after the webinar is concluded, please feel free to reach out to us and we will be happy to help. Thank you again, and we hope you all have a wonderful day. Thanks, Saul.
Thank you.